Well, good morning, everyone. Thank you very much for being here on this important morning for us to discuss some of the issues that our constituents have been reaching out to us about. These issues are the issues that we do not rule on here in the State House of Representatives or the Georgia Senate. These are the issues that are ruled on in the Supreme Court of the United States. And we are standing here today to make sure that our constituents are hearing from us on how we see that these issues and rulings will impact the state of Georgia. To start us off, we will have a bit of a briefer on what the state of the Supreme Court is. Are there confirmations happening? Are there rulings happening? And that will come from Representative Deborah Gonzalez.
Good morning. My name is Deborah Gonzalez, and I am the representative of House District 117. This morning, I will give a few brief comments about the current situation with the vacancy and nomination of a Supreme Court justice to replace retiring Justice Anthony Kennedy. The Supreme Court forms part of the third branch of the federal government. It was created by our forefathers to serve as a check and balance to the legislative and executive branches by being the designated arbiters of our country's laws. There was a time when the objectivity of those justices were never called into question. There was a time when we trusted that the justices appointed to the Supreme Court would take into account and apply the laws of our land to the facts of the case and not be a means to promote and ensure a particular political party's agenda. That time has passed, as recent Supreme Court decisions have come down along party lines. We have also seen the politicalization of the Supreme Court begun with Senate Majority Leader McConnell refusing to permit our former President Obama from appointing a Supreme Court justice upon the death of Justice Anthony Scalia, insisting it was too close to an election. That election was over 237 days away. This election is a little over 150 days away. Why the same reasoning is not applicable now, according to this McConnell rule, leaves little doubt as to the political games being played out at our expense. Yesterday on Monday, President Trump interviewed 4 potential nominees: Judges Raymond Kethledge, Amol Tapar, Brett Kavanaugh, and Amy Coney Barrett. Each of these was on a list first made public by then-candidate Trump, which was compiled by a conservative think tank. We are told these interviews lasted 45 minutes each, and that Trump would not ask any nominee about their views on abortion or other civil issues, saying it was inappropriate to discuss. But we believe appropriate it is, as the next justice will surely be instrumental in the potential overturn of a litany of civil and social rights: abortion, same-sex marriage, the Voting Act, the Civil Rights Act, the Equal Rights Amendment, and the list goes on and on, as my fellow representatives will speak about them next. The impact of this new justice will be felt for decades to come, as their lifetime appointments affect multiple generations. A lot of the rights we Americans have worked and fought hard for are on risk to be ripped away from the stroke of a pen or a key. The courts are no longer an objective, unbiased, non-political entity. The newest Justice, Neil Gorsuch, has demonstrated his willingness to toe the party line in his decision-making. Decisions are being made not in the best interest of the public, but in the personal interest of a privileged few. Considering the duration of the impact of this new justice, we implore U.S. citizens to reach out to their senators who have the power to confirm or not the appointee, and insist that no appointee be considered until after the midterm elections, based on the McConnell rule implemented in 2015-2016. And we also request that our senators not vote to confirm until then as well, demonstrating to all of us that they are willing to put country over party. Thank you.
And to enumerate one of the first issues that our constituents have reached out to us about, I will speak on the issue of the woman's right to choose. In 1973, a decision known as the Roe v. Wade decision came out in favor of a person's privacy, a right to privacy, specifically in this medical circumstance. We then, of course, saw a Casey versus Hellerstedt decision, and we also continued most recently to see a decision coming out of California, Nilfa versus Becerra, which makes it so that, unfortunately, our Supreme Court sided with the way that the state of Georgia has, which is to allow for crisis pregnancy centers to not speak to the truth of what they do behind their doors. We know it is important that women and families are able to control their narrative and control their bodies and have access to the services that they know are medically necessary and incredibly safe. I am standing here along with my colleagues, very proud to continue to support a woman's right to choose and look forward to hearing from our next speaker, Senator Nan Orrock, on environmental issues.
Good morning. We're joining voices today as state policymakers to send a message to Washington and go on high alert about the incredible, lasting impact, as we've heard from other colleagues just a moment ago, on the course that public policy takes across this great nation. I want to flag for you, in particular, the protections that have been fought for and put in place over decades to protect and restore our environment for generations to come. As a law professor was recently quoted, he said, "There's no happier person in America right now than Scott Pruitt, the man who is decimating the Environmental Protection Agency." Because Justice Kennedy was the swing vote in sustaining environmental decisions over the past decades. In fact, only once in all those years did he not vote on the side of the environment. He has been, again, a firewall, and we very much fear a midterm appointment in the midst of elections could mean there's one more vote on the Supreme Court to strip the EPA of its power to regulate. The Waters of the United States rule put the Clean Water Act protections on 2 million miles of streams and 20 million acres of wetlands. We have a great stake here in Georgia around protecting our wetlands and our waters. But what state and what citizenry doesn't have a great stake in having their environment protected? 1/3 of Americans get their drinking water from sources connected to these streams and wetlands, and they warrant this federal protection. And Justice Kennedy's opinion in the 2006 case, Rapanos versus United States, established elaborate tests to determine which bodies of water could be regulated under the Clean Water Act. Kennedy was the middle vote. It was 4-4, and he cast his vote on the side of the environment. As we stand here today and think about the egregious turnarounds going backward that could come from a stacked Supreme Court, we think it's time to sound the alarm. And I want to say that Scott Pruitt's regulations that he's proposing and the ones that he's decimating and taking apart would turn us backward. Over 60% of protected American waters now would lose federal protection if that Clean Water Act were to be reversed. And the Clean Power Plan is yet another area on the question of emissions. So as the Supreme Court looks ahead to its new term beginning this fall, we are but a few of the voices that are being raised across this country and in the U.S. Congress to say caution, caution, proceed with care, because the implications, the long-term impact of this next judicial appointment to the Supreme Court of the United States will mean everything. Ask any parent in Flint, Michigan. Ask any family whose home has been devastated by a wildfire or a hurricane. Ask any rural community that's drinking polluted water from the Mississippi River. They'll tell you the Supreme Court's decisions on environmental regulations will have a dramatic effect on America and on our lives of our citizenry. Thank you.
Thank you, Senator Orrick. My name is David Dreyer. I'm the state representative for House District 59, and I want to talk a little bit about how the Supreme Court appointment could affect voting rights and the franchise in Georgia and elsewhere. A while back, Congressman John Lewis, my congressman, marched and fought for the Voting Rights Act. That contains Section 5 of the Voting Rights Act, which required states with a history of racial discrimination to have any changes to the voting system approved in advance by the Department of Justice in Washington, D.C. And that was done because of continuous voter suppression efforts. As soon as one would be knocked down, another one would be popped up. The system that was put in place is if a state, such as the states in the Deep South, had discriminated, they had to get pre-clearance from the Department of Justice. Recently, though, in 2013 in the Shelby decision, the Supreme Court said, we're no longer going to require states with a history of racial discrimination to get pre-cleared on changes to the electoral system. You know why they did that? Because the Supreme Court justices said there is no longer racial discrimination in our country.
My.
Something. You know, if I was driving from a $2 million home in Washington, D.C. with a private driver to the Supreme Court building, maybe I would be a little out of touch too. But I know the people in my district know that there are systems of racial discrimination, racial oppression, and attempts to disenfranchise people every day. Since the pre-clearance and Shelby decision, over 850 polling places in the South have been closed. That's only a partial number because we don't have numbers from many states. Half of all counties covered by pre-clearance have had polls closed. So as soon as this decision was enacted, voting suppression has continued apace. In Georgia this past session, we split up the city of Stockbridge. We took away the right of many minority voters to have a say on their mayor, and we split the General Assembly. I won't say we because we voted against it.
We voted against.
The General Assembly voted for that over our objections. And if Shelby had not been the law, if pre-clearance had been in place, because that change would have affected minority voters, it would have had to gone through the Department of Justice, and then we would have had more grounds to challenge it, and it would not have passed. This is a new thing.
That's right.
And this bad decision has affected the municipal bond ratings probably of every city in the state of Georgia. This wouldn't happen but for far-right Supreme Court's appointments. Because of rulings like Shelby and Citizens United, which if you remember, said corporations have the same rights as individuals, which anybody with any sense knows is completely false. Our democracy continues to be degraded to the point where only about 40% of the eligible voters in this country cast a vote for president in 2016. One last thought, what would happen if 90% of eligible voters cast a vote? What would our policies look like? Would we have health care for everyone? Would we have employee protections? Will we have environmental protections? I think some people know the answer to that question, and that's why there is an effort to put far-right Supreme Court appointments that look out for corporations and special interests and not individuals. Thank you for being here. Our next speaker is Senator-elect Sheikh Rahman. Thank you for being here.
Great.
Thank you. My name is Sheikh Rahman. I'm a senator-elect from District 5 in Gwinnett County. As you know, Gwinnett County is as diverse as probably, in New York City. We have people from all over the world, and we speak all different languages. So what's going on in the country right now, it affects all of us living in Gwinnett County. So I'd like to talk about the travel ban and a little bit about what's going on with the child separation right now. I can tell you something firsthand, the experience that I had during 1971 as a child, born in Bangladesh, we had a civil war, and I was detained by the military. They were trying to get to my dad. So I'm still suffering 40 years later on, the traumatic situation that I had. So nobody can tell me that it's not affecting. It still affects me, just speaking right now. So if somebody thinks this is a joke, what's going on, it's a child separation, they have no clue. They have no clue what's going on and what is going to happen to these thousands of children in the near future. I am the living testimony of that. Let's come to Trump travel ban. The Trump travel ban is nothing but a first step in his openly stated state intention of total and complete shutdown of the entry of Muslims to the United States. The recent Supreme Court rulings upholding this Muslim travel ban is a reiteration of his racially charged and disgraceful decision of 1944 in the Korematsu case executive decision, which ordered Japanese Americans into internment camps during the World War II, regardless of their citizenship. Both rulings are racial and ethnic injustice veiled under the guise of national security. This is a baloney. Thank you, appreciate it. Next speaker will be my leader, Dewey McClain.
Good. Thank you, Sheikh. Good morning, and I want to make sure that everyone knows that what we do have with the Supreme Court. I'm here to talk about workers and employees. You know, I'll tell you on the Supreme Court on June 27th, they struck a blow to workers. They gave corporations more power than ever. This was the Janus versus the ASME 31 case on June 27th. We talked about bipartisanship, straight party line, 5-4. 5 Republicans who were Supreme Court justices, they voted with Janus. So what I want you all to realize is that hurts all of workers, not only just workers in Georgia, but workers all over America. So what do you say that this decision does? This decision mandates that unions to represent public sector employees, regardless if they even pay a penny worth of dues or fees. You know, so this puts the back on workers that do pay their dues, that do pay their fees. So now that is wrong. That is what I call really wrong. When workers have to pay, everybody must pay their fair share. And I think that's when a group does that, what does that say to us? This was a 41-year-old case. This was already ruled on. This was ruled on in 1977 already.
That's right.
So what do we do in 2018 once we get one more Supreme Court justice? What do? We decide that we're going to overturn something that's 41 years old. So what's next? What is next? Roe versus Wade, is it next? So all I want us to realize is it is very important that we step up, that we make sure that we step up to make sure that all of our needs are met. Now, what was the message that was sent down on that decision? They want to discourage all of us from voting. But what we must do is we must vote. We've got two things in the workers. Workers and employees have two things they can do. They have their voice and they have their votes. And what we've got to do is to make sure that we can all come together in solidarity and stick together. We must stick together as workers because what do we all do? Work. What are we? All employees. So if you come at the public sector right now, what are you coming for next? Well, I'll always say that one thing about us in Georgia, I can always say every year for the past 5 years, our governor, Governor Deal, has said that Georgia is the #1 place to do business. I've heard that for 5 years, of the 5 years I've been here. But not once has he ever said that Georgia is the #1 place for people to work, for people to live, and people to raise their families. Not once. But it's always about corporations. It's always about business, but it's never about the individual. Well, I just want you all to know that Dr. King said something. And what Dr. King said was, Freedom is never voluntarily given by the oppressor. It must be demanded by the oppressed. And right now, I think all of us feel that we're oppressed, and we all must double down and say our voices and say our votes and go out. Thank you all very much. Thank you.
Good morning. My name is Nguyen, and I represent House District 89, and I'm here today to read remarks from my colleague, Representative Sam Park from District 101. The recent masterpiece Cake Shop Supreme Court opinion, which on narrow grounds ruled in favor of a baker who refused to make a wedding cake for a same-sex couple, reinforced the general rule that religious objections do not allow business owners and other actors in the economy and society to deny protected people equal access to goods and services under a neutral and generally applicable public accommodations law. The opinion also demonstrated that Georgia needs comprehensive civil rights legislation to prohibit discrimination in employment, housing, and public accommodations for everyone, including the LGBTQ community. That's why Representative Sam Park was proud to be a co-sponsor, along with my Democratic colleagues, of House Bill 987, which would have set forth protections. And we will continue to advocate for legislation, especially because we are only one of 3 states in the nation that do not have comprehensive civil rights. Moreover, we do not need additional religious liberty legislation. The First Amendment of the U.S. Constitution sufficiently protects the free exercise of religion without additional state legislation, as evidenced by the result of the existing case. Further, as the U.S. Supreme Court has said, the First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faith. We must put an end to using religion as a sword to attack minority communities, and we must find on working the right balance between protecting civil rights and equal dignity of the LGBT community. The General Assembly, year after year, has already shown that voters will not allow us to discriminate against the LGBT community, and we will continue to fight against any religious freedom bills that we will see in our state of Georgia. Thank you.
Hi, everybody. I'm State Representative Renitta Shannon, and today I'll talk to you about affirmative action in reference to the Supreme Court. Talking about affirmative action, we've seen attacks on affirmative action policies year after year, and these types of decisions in reference to the Supreme Court have not been discussed enough in the media, I believe. Affirmative action programs have played a critical role in opening up opportunities for women and minorities to begin to take their rightful place in our society. But equal opportunity is still a long way off for both groups. Eliminating or curtailing affirmative action would not only halt the forward progress that women and minorities have been able to achieve, it would also mark a giant leap backward in this nation's journey toward equal opportunity for all. Affirmative action works, and we still need affirmative action policies in place. While women are over half of the adult population and nearly half of the workforce in this country, they remain disproportionately clustered in traditionally female jobs with lower pay and fewer benefits. And although white men constitute a minority of the total workforce at 46%, they still dominate the top jobs in virtually every field. A government study showed that women and minorities made greater gains in employment at companies doing business with the federal government because they were subject to federal affirmative action requirements than at other companies. Female employment specifically rose 15.2% at federal contractors and only 2.2% elsewhere. The same study showed that federal contractors employed women and minorities at higher levels and in better paying jobs than other firms. Many individual companies that have adopted affirmative action plans have demonstrated the impact on women and minorities. For example, after IBM set up its affirmative action program, its number of female officials and managers more than tripled in less than 10 years. Corporate commitment to women and minorities enabled Corning Corporation to double its number of female and Black employees and increase the proportion of women managers. The last time affirmative action was upheld by the Supreme Court was in 2016. in a 4-3 vote by retiring Justice Kennedy. The slender majority demonstrated that affirmative action is hanging on by a thread. Meanwhile, Trump's DOJ is investigating and suing universities over affirmative action policies, alleging that they are deemed to discriminate against white applicants. The statistics are clear. We need a Supreme Court that will uphold advancing progress and equity for all through continuing affirmative action policies because they work. And next we'll have State Representative Kim Schofield.
Good morning. I'm State Representative Kim Schofield, and I represent District 60. A little on the travel ban, I really want to be clear as a parent how disgusted and deplorable it is the way that we are taking care of what we call our precious cargo, our children. In the wake of just health care, I have the question that I'd like to know to be answered. Who is mandating that these centers where these children are being held, that they have medical records, that we're taking care of the health needs of our children? You know what keeps me up at night is, as a mom, is the blatant disrespect that we have shown. So my colleagues and I stand here today to be that voice, to be that strong voice for Georgians to say we're not going backwards, we are going forward, and no longer will we allow this nation, these appointments to override the basic needs of humanity. Thank you. At this time, I would like to open it up for questions.
Speaking more about the possibility of a Berkeville being turned over, marriage equality rights being taken away.
Marriage.
Just repeat the question one more time.
Can you speak a little more to Berkeville possibly being turned over, and marriage equality rights being taken away?
A little bit more about possibly marriage equality being overturned. Well, the remarks of Representative Sam Park, as well as the remarks of Representative Carla Drenner, echo the sentiments that we have made here today, that we already know that there are First Amendment opportunities for people to exercise their religious beliefs. We do not believe that that should continue to overrule our issue related to marriage equality. People should be able to love and care and take care of the individuals who they decide to. That is not something to be decided by the Supreme Court or any masterpiece cake decision maker. We here in Georgia are excited about the opportunities to keep Georgia Unites Against Discrimination together and to push back on any policies that would not allow for the full comprehensive civil rights of LGBTQ Georgians to be upheld. Well, we thank you for coming out today, and we look forward to watching how the appointment of our Supreme Court continues to go. We are excited about the opportunity for Georgians to cast their votes right now at the ballot box as early voting is open across the state of Georgia. And if we can do anything here, please do reach out to us as we are looking over these issues, and we'll be back in legislative session to talk about them as well. Thank you very much.
Thank you for staying around another minute. I'm Senator Elena Parent, and there's one more critically important topic that I wanted to draw the public's attention to in relation to how absolutely important this Supreme Court vacancy is. The topic of gerrymandering and drawing district lines is another topic that is frequently at the federal courts of all levels, and recently the Supreme Court has been delving into this topic on a regular basis. Gerrymandering, which I like to call the practice of drawing lines to pre-rig or predetermine the outcome of elections, is one of the biggest scourges in our democracy. In the last several decades, this practice has gotten worse and worse as computer technology has improved. It's become possible to surgically add voters to and remove voters from districts in often successful attempts to lock in the partisan and racial tilt of districts for up to a decade. That's right. This means that no true, fair election occurs right up until the next round of census-driven redistricting has to occur, conceivably allowing a party to control the electoral outcome of state and congressional seats for decades on end. Rigging elections through gerrymandering is undemocratic and goes against all of the ideals that America is supposed to stand for. Citizens of all partisan persuasions are opposed to this manner of removing electoral power from them. One egregious example of gerrymandering is at work in North Carolina. This is one of the cases before the Supreme Court. It is a 50-50 electoral state in recent elections. The voters voted for Barack Obama in 2008 and Trump in 2016, while also during the 2016 elections tossing out their Republican incumbent governor in favor of a Democratic governor. However, the congressional delegation going to Washington from the state of North Carolina is 10 Republicans and 3 Democrats in a state that is a 50-50 partisan bent state. The leaders of the state legislature have admitted publicly that they did everything they could do to maximize Republican districts and disempower Democrats. This is viewpoint discrimination in violation of the First Amendment of the Constitution. In order for our citizens to believe that their votes count and that they have a say in who their representatives are, as is claimed by the leadership of our country, for there to be a contest of ideas between the parties, for America to really even be able to call itself a democracy with a straight face, districts must not be so skewed that elections no longer matter. This is one of the very serious questions that is before the Supreme Court. We need our courts to rein in these extreme abuses, because if they do not do so, the foundations of our democracy are at risk. Gerrymandering puts the rich and the powerful in control instead of the people, and therefore violates America's most sacred values. This and many of the other topics that you have heard about from our colleagues today are so important, and we need to impress upon all the voters and the citizens of Georgia and this country how important it is to have a fair-minded jurist on the Supreme Court who will give a fair listen to all of these critical issues and not rotely side with those who are already in power and who are already wealthy and powerful. They already have a hand up in most of the way our country functions, and unfortunately, with a Supreme Court that is skewed, that problem could only become worse. And we need Americans of all stripes to rise up and make sure that they are the ones empowered to have their voice heard in fair and open elections that have not been predetermined. Thank you very much for your time.
We would add one note to our comments today, and that is that we call on our U.S. senators from Georgia, Senator Johnny Isakson, Senator David Perdue. You supported Senator McConnell when he suspended the hearings on filling the Supreme Court vacancy when Obama was in office. That same situation prevails today, as earlier speakers have pointed out. It's just 100 and a few days counting until a major election across this nation. You have a president who's under criminal investigation, who would be choosing his own judge on the Supreme Court. Were we allowed to go ahead as a Senate and ratify a Trump appointee? So we're calling on our senators, stay consistent. Don't be hypocritical. The last time there was a vacancy on the court, you supported the notion that we should wait until elections were held before any justice appointment was considered. We ask you to stay consistent and uphold that line in the sand that Senator McConnell drew, and wait until the elections are concluded in the fall, and do the appointment of the replacement for Kennedy under the administration, under the Senate that is seated in 2019, January. That is what we call upon Senator Isakson and Senator Perdue to stand by the position that they backed the last time they were presented with this question of when to take a vote to ratify a presidential appointment to the Supreme Court of the United States. Thank you.